Good morning. It's Andy Stautz with Stautz Law, and I am back for another talk about Indiana estate planning and probate topics. Today's talk is a follow-up on a talk I made a long time ago about time limits for Indiana probate. And you should probably watch or read the transcript of that talk first, in which I discuss the basic time limit of 3 years to probate a will. And I discuss in that talk one way around the 3-year limit, which comes if there is still an asset titled in the name of the decedent after 3 years. So the basic rule is if you've got the will, you need to get it to court, you need to get it probated in the first 3 years after the person dies. But if for some reason you forget, there's kind of an escape hatch for longer than 3 years when the title is still in the person's name. Okay, I'm coming back to say that doesn't always work. It's one possibility, but there are other ways that the time limit can be cut short, or that the escape hatch for assets titled in the person's name won't work. Okay, so the first thing is, once there's been an estate administration, it's too late to probate the will. So we're talking about this same section of the Indiana Code, 29.1.7.15.1. Okay, Section G is where the time limit is. Section A says, but if an unsupervised estate is over, it's over. It's too late. Once you've done this intestate administration, it's too late to come forward with a will. Okay, so that's one firm cutoff, right? If there's an administration on the estate, that's the time to get the will out in the open. The other problem that I want to mention is the escape hatch, which is down in subsection H, only applies to assets titled in the name of the defendant. So if something has happened and the property has changed hands, gone away, passed by a title passage or devolution affidavit, you can't use that subsection H to rescue the administration and to introduce a will. Okay, because it's been dispersed. Okay, so moral of the story is administer estates when someone dies, or decide you don't need to, right? But don't wait. It's really hard for me as an attorney to help a client or a potential client who says, oh yeah, so-and-so died, 5 years ago. It's like, well, okay, what are you waiting for? That introduces new problems that wouldn't have been there if it was, okay, 6 months have gone by, now we're ready to administer. It doesn't need to be right away, but these years, the more years go by, the more problems you're going to have, practically as well as legally. So hope that helped as a general informational talk. I just needed a corollary out there to the previous talk. And as always, that's general discussion of the law. If you want specific legal advice, you're going to have to call me or shoot me an email. You're on my website. Thanks. Bye.